Good morning, everybody. Thank you for joining us for this Thursday morning COVID-19 Miller-Johnson webinar. Today we'll be talking about some recent developments related to the Paycheck Protection Program. My name is Erik Daly. I am a partner in the firm's corporate section, and I've been involved with my colleague and partner, Jeff Muth, who is a partner in our litigation group, in organizing our firm's multidisciplinary approach to the CARES Act and the Paycheck Protection Program specifically. So what we're planning to talk about today, and our goal is to keep the program tight so we can get the information across and let folks go on with their day. But the goal today is to talk about the recent Interim Final Rule that the SBA released relating to the process for appealing Paycheck Protection Program loan-related determinations. But before we get to that, we'll go through this agenda, just take stock of kind of the current status of the PPP, then we'll get into detail about kind of the IFR release and some of the key takeaways, do a quick summary, and then talk about our firm's compliance readiness program specific to the PPP. So with that, why don't we move into the substance of the program? The PPP closed to new applicants on August 8th. And at that time, there was about $134 billion in appropriations for the program that were not yet used, that had not been lent, or some portion of that, represented funds that had been returned by borrowers who concluded that maybe they didn't need the loan after all. But in any case, there was a significant amount of kind of leftover appropriations at the time that the SBA stopped accepting loan applications. The following Monday, the SBA opened up its forgiveness portal for accepting forgiveness applications from lenders. Some banks did start accepting forgiveness applications, and actually some started accepting them. I think I would say fewer, relatively few started accepting them before August 10th, just to get their borrower clients to be in a position to remit the information to the SBA. I think most banks, especially the larger banks, were really still developing their internal portals and or waiting for additional SBA or Treasury guidance about the forgiveness process, or possibly they kind of blanket forgiveness for loans below a certain threshold, or streamline forgiveness processes for loans below a certain threshold. So some banks may still be in a bit of a holding pattern while they await any further regulatory or legislative developments. Let's move on to the next slide. And then on, I guess it was Tuesday, August 11th, the SBA released this Interim Final Rule, which we'll talk about today, which discusses the process for appealing SBA loan eligibility, really specific to the PPP loan eligibility and forgiveness determinations. And the Interim Final Rule basically amended, added a new section to the federal regulations that govern SBA administrative proceedings. They describe the process for review and the steps that borrowers must follow in order to properly preserve their appeal rights if they ultimately want to work their way through the administrative appeals process to actually get in front of a non-administrative or federal court judge or magistrate, somebody outside of the SBA administrative apparatus to have a hearing on their appeal. And we'll get into more detail about why this is the case, and Jeff Muth can provide some more context for why this is the case. But really, this IFR and the rulemaking as a whole strongly favors the SBA's initial determination or determinations about eligibility and forgiveness, and it makes it very time-consuming, opaque, and expensive potentially to really pursue your appeal all the way up through the process you need to follow in order to even get a day in actual federal court. So why don't we dive into the takeaways? Like I said, we'll try to move through this quickly. First takeaway relates to who can actually lodge the appeal. And it's only the actual borrower, so the named borrower on the PPP loan file or loan application. So that means that individual owners of a borrower, so if you have a company that's owned by 2 or 3 people, for example, no one of them individually would be able to file the appeal. It has to be filed by the actual borrower entity or individual. And lenders similarly do not have standing to appeal. That's sort of interesting, probably not real relevant to a lot of borrowers, but maybe of interest to some lenders, since I believe if the SBA determines that a borrower was not eligible to receive a PPP loan in the first place, then they need to return the origination fee for that loan. So it is interesting, at least from the lender perspective, that they don't have standing to appeal those eligibility determinations. Next slide, please. Okay, so that's who can appeal. What can actually be appealed? Importantly, the appeal process only applies to final SBA decisions. And so before you get to that final SBA decision or determination, there will be some sort of back and forth between and among potentially the lender, the borrower, and maybe the SBA, where the lender will make an initial determination of kind of loan forgiveness, eligibility, whether it's full or partial or none, basically. Submit that to the SBA. The SBA may come back and ask for additional information. They may reject the determination because there's not enough information in the file and you have to go through the process again. So there's this sort of preliminary process, I'll call it, where there may be some information requests that go back and forth before you actually get a final SBA determination that can actually be then appealed through this process. And the appeals IFR does not apply to that initial back and forth. So there's a separate kind of, I'd say, less formal process that will apply when you say you get a letter from your lender initially saying that, we've transmitted your application to the SBA and we're disallowing 10% of your forgiveness request for the following reasons. That is not something that this IFR applies to. It's only once the SBA actually has said in final written form that here is our decision, our final decision as to one of the following things: ineligibility for a PPP loan, ineligibility for the amount of the loan received. So that would go back to your loan calculation that you originally did based on average monthly payroll costs. Unauthorized uses of PPP loan proceeds. So if the funds were spent on something that's not permitted under the program rules. And then ineligibility for forgiveness, either based on the lender determination, or if the lender has issued a full denial, you can appeal the determination of ineligibility for forgiveness in any amount, if that's the case. One other note before we move on from this is that this rule, since it only applies to SBA decisions, final SBA decisions, does not apply to, for example, Office of the Inspector General disputes. If you were to be audited by a different branch of the government besides the SBA, these rules would not apply, at least as things currently stand. You'd be dealing with, whatever rules of whatever agency or oversight body had requested information or made a determination about use of funds or eligibility. So again, this is very specific to final SBA determinations. Jeff, is there anything you want to add at this point before we keep going?
No, just for a point of clarification, typically a borrower would only be subject to the Office of Inspector General inquiries in instances where there had been allegations or maybe even whistleblower complaints regarding fraud. So, typically for the standard PPP borrower, you're going to probably find yourself going through this process as opposed to a OIG process.
Okay, good point. Thank you, Jeff. That reminds me, I should remind people again that I'm sort of just the transactional attorney, and I'm going to kick it to you on a lot of these process points, given your experience before a lot of these types of agencies and kind of more enforcement and litigation related matters. So why don't we keep going? I'm sure you'll be able to add more color on some of these other points too. So who do you make appeals to? Jeff, you alluded to this, I think, just now, but the appeal of a final SBA determination goes to the SBA's Office of Hearings and Appeals, or OHA. So you're not appealing immediately up to the SBA administrator or court. You've got to first go to the OHA, which is sort of an appendage of the SBA administrative apparatus. And that appeal must include a variety of things, some financial information and data, mostly related to employee-related costs and related tax documents. And then, importantly, it needs to include a full and specific statement as to why the SBA loan review decision is alleged to be erroneous, together with all factual and legal arguments supporting the allegations. And that, Jeff, maybe you're more comfortable with this kind of limitation, but that's got to all be included in 20 pages. That doesn't include, sort of attachments and exhibits, but the argument, the initial appeal argument really needs to be limited to 20 pages. And you can't add new materials to the record at that time. That seems like a pretty meaningful limitation, given how dense and frankly confusing some of the PPP regulations are, even to those of us who have been, kind of swimming among them, swimming in the depths of the PPP waters for the better part of 5 months now.
Yes, Eric, and I think you'll probably get to this in the next slide or two, but it really underscores the importance of borrowers being able to, within that page limit, within the time allowed, to create a full administrative record, because that is the record that not only OHA is limited to reviewing and making its determination, but if you appeal from the OHA's determination to federal court, their review is limited to the administrative record. So it really underscores the importance of the borrower's ability to build out, a full administrative record to support its determination for eligibility, forgiveness, and the like.
Right. Yeah, we definitely will touch on that more as we go. That'll be, I think, a continuing theme here. So let's keep moving. The next takeaway, and you alluded to this, Jeff, how quickly does the initial appeal need to be made? So you have 30 calendar days to make the appeal after you either receive earlier of your receipt of the final SBA loan review decision. So if you've received that determination directly from the SBA, or if you've received earlier notification from your lender, you have 30 days from that date. So again, you've got a relatively short amount of time to put together that full and complete argument of facts and law, limited to 20 pages, to begin the appeals process and really kind of set up, kind of lay the groundwork for what may follow if you're going to be appealing up even higher than that. And that's not a lot of time to gather or, worse, reconstruct, especially if this is happening. It could be happening a year or two from now when people have moved on, hopefully, from some of this. Okay, let's keep moving. The standard of review and burden of proof, basically, again, very favorable to the SBA. I don't know that this is surprising necessarily, but it's got to be basically a clear error of fact or law. And again, this is, and at least in the first instance, this is an appendage of the SBA determining whether the SBA itself made a clear error of fact or law, and the burden of proof is on the borrower by a preponderance of the evidence to show that that was the case. So that's a high hurdle to overcome in the first instance. And I get the sense that in many cases, this first part of the process, and this may be jumping the gun on some of our conclusions later, but really the first part of this process in terms of appealing through the OHA in a lot of cases may just be, you've got to go through that check the box sort of exercise in order to get to the next phase of the appeal, and you're not really expecting to get kind of the substantive result you want at this initial stage. And it's more about setting up a good track to follow in the subsequent phases of the appeal process. Let's keep moving to the next takeaway, number 6. Who reviews the initial appeal? Again, it will not be a federal district court judge or magistrate unless the SBA and the borrower agree to some kind of alternative dispute resolution, which we'll get to later and is a possibility. It'll be an administrative law judge or an administrative judge that the OHA assigns to handle the case. Next slide, please. Will there be discovery? Generally, there will not be discovery at this stage in the process, and this is, from my perspective anyway, this is very, very important. The SBA will be charged with providing the administrative record, which is, generally all that the administrative judge is going to be is able to rely on under the rules to make a determination. So there's no discovery, and really the administrative judge is limited to the record that the SBA had available to it at the time of its final determination. And even there, the SBA, under the rules, doesn't need to provide every single document that was provided to it. It just needs to provide, kind of what it believes it relied on in making the determination. And there's some ability for the borrower appellant to object to the absence of documents or information that should have been included. But again, that's still only going to be limited to things that were provided to the SBA, but which they left out of the record and which the borrower timely objected to the absence of. And I think this is an even shorter time frame on rules than 30 days. I think it might be 10 calendar days, but you have a very short time frame to go through the administrative record and identify, potentially important pieces of information that were provided to your lender or the SBA, but which were omitted from the administrative record. Next slide, please. No oral hearings either, generally. There will not be any oral hearings on appeal. And only if the administrative judge determines that there's a genuine dispute of material fact that can only be resolved by taking a testimony and confronting witnesses. So there's no, it's not your typical process, I guess, that's at least I imagine litigators going through, where they submit their written arguments and then there's some oral hearings in front of the judge where there's further elaboration of those arguments. Really, we're just, again, going on the administrative record, the initial appeal, and then the SBA response to that appeal. And the borrower generally doesn't have any ability to respond to the SBA's positions. So, the kind of process will be a written appeal by the borrower, a written response from the SBA, and then I would say in most cases, the administrative judge is going to be proceeding without any further information besides the administrative record. There won't be additional discovery, no oral hearings, and no further reply to the SBA's positions from the borrower, at least at this stage. Jeff, is that how you and kind of your takeaway from this as well?
Yeah, I mean that's correct. I mean, when you find yourself in an appeal process where you have essentially the administrative agency adjudicating the prior decision from the same agency, it's a bit of a kangaroo court, and the deck is certainly stacked against the borrower. In very few instances would I ever expect the OHA to overturn the SBA's final determination, and
right.
it really limits borrowers' ability to mount kind of a fulsome legal attack on that determination like they would be able to if this was a federal or state court proceeding.
Right. Okay. I just wanted to make sure I wasn't way off base here. Doing pretty well so far in terms of summarizing litigation and procedural issues as a corporate attorney. So let's keep going and see if I can keep that up. We touched on this earlier. Alternative dispute resolution is a possibility, but only if the borrower and the SBA mutually agree to that and then submit a joint motion for ADR. That can be done at any time during the appeal in front of the OHA. I don't know how, I'd be speculating as to how frequently the SBA would be open to that. But I guess we'll find out as the process proceeds. I suspect if the borrower and the SBA have agreed to submit that joint motion, that the administrative judges will be fairly inclined to, allow them to pursue that option. I don't know how often the SBA will pursue that. Next slide, please. So are there any other avenues for appeal? We've kind of mentioned ahead of time some of these, but the first potential would be a request for reconsideration by OHA. So this would be, I guess, in a case where there was just some really obvious error of fact or law in the initial decision from the administrative judge. And really any of the parties involved could request that reconsideration, including OHA itself, at its own initiative could reconsider its decision, which seems odd to me. But and then the next appeal that a borrower would need to take in order to preserve its ability to actually have a day in court ultimately would be appealing the OHA decision to the SBA administrator for review. And there's really not a lot of detail in the interim final rule about what this appeal to the administrator would look like. There may be other existing federal regulations in the SBA context that would control here. But so that's the next step in the process one would need to follow, and we'll see if the SBA puts out anything that's PPP specific in terms of what that appeal process looks like from a timing or an other substantive perspective. And then lastly, if a determination by the SBA administrator has been received, then and only then can there be an appeal by the borrower to a federal district court. And otherwise, if you don't timely make all those appeals, then you basically waived your right to appeal to a federal court. So really, this is sort of a test in process, and especially early on, making sure you don't miss any of these deadlines, and making sure, as Jeff was saying before, and we'll get back to this, that you really kind of lay the groundwork for a successful outcome by getting the documents that you want and the information you want into the administrative record before it's too late. Next slide, please. Does an appeal delay loan repayment timing? No, it doesn't. The IFR makes it clear that the same general rules that apply to the deferral of payments under the PPP loan program will continue to apply, and really the appeal itself has no bearing on that. So once the SBA remits some or all of the requested forgiveness to the lender, the appeal, that's kind of the relevant trigger, if you will, for setting up the timeframes for repayment, not a final decision on appeal. And if you overturn the decision on appeal, if you're successful, for example, and overturning, then there will be a way to settle up with the bank with the lender and the SBA to recoup the money, I guess, that should have been forgiven but wasn't if you were successful on your appeal. But it doesn't push that initial repayment date out further based on the pendency of the appeal. Next slide, please. Attorney's fees are not recoverable on appeal. Even if you ultimately prevail, this is all at the borrower's expense. I don't know that there are really any exceptions. I guess maybe Jeff is aware of some exceptions if you get to a federal court and there's been some really bad faith arguments made or something like that. But in general, basically, even if you're ultimately successful and it's really clear cut from the beginning that should have been the outcome, the borrower still has to go out of pocket on attorney's fees and other fees that it incurs as part of this process, costs of kind of going through the appeal. Is that right, Jeff? Is there anything I'm missing there, or is that basically a blanket statement that you're not going to get any of those fees back?
No, that blanket statement is correct. There would have to be something set forth in the regulation or the statute that specifically provided the borrower the right to recover its attorney's fees. So the borrower will be responsible for and incurring its own attorney's fees throughout the appeal process.
Okay. All right. Next slide, please. All right. So in summary, as we started out by saying, the appeals process really does favor that initial SBA determination. And maybe I'll kind of turn this over to Jeff at this point, because I think he's in a good position to kind of holistically take stock of, kind of what the rules strategically, stepping back from each of these, individual rules of the road. What does this really mean strategically for borrowers now, before many of them have submitted their loan forgiveness applications and really triggered, timeframes that will result in a potential appeal? What does this really mean? So,
yeah, sure. Thanks, Erik. you know, really the moral of this IFR is that borrowers do not want to find themselves in the position of being an appellant appealing an adverse SBA initial decision. You know, as we walk through the procedures involved in an appeal, it should become abundantly clear that those procedures greatly favor the SBA in making its determination. And even when you get to federal court, an agency's interpretation of its own regulations is entitled to significant deference. Now, you know, there are exceptions to that rule. You know, an agency's interpretation of its own guidance of those regulations is entitled to less deference. But the appeals process definitely favors the SBA and its determination. So from a borrower's perspective, you know, what we're advising clients is you should put yourself in the best position to avoid this process altogether and to receive a favorable SBA determination regarding eligibility and forgiveness. And, you know, we've been working with a number of clients in this regard through our PPP compliance readiness program, where we're really assisting clients prospectively, a bit prophylactically, under the old adage, an ounce of prevention is worth a pound of cure, to really build what would become that administrative record now. When you have the benefit of time, the benefit of recent memories, and documents have been somewhat contemporaneously created to best position our borrower clients in working with their lenders to receive a favorable determination from the SBA based on, you know, the record keeping, the documentation, and then the contemporaneous justification regarding, you know, the application as well as the forgiveness process. So, you know, the takeaway, I think it underscores what Miller Johnson started doing a few months ago. We certainly weren't clairvoyant and didn't expect this exact IFR to come out, but I think we did anticipate that any appeal process with respect to the PPP program would greatly favor the SBA, and it really kind of set the tone for this PPP compliance program that we rolled out a few months ago, and maybe some of you are currently participating in.
Right. I know we have some more information about that at the end here, but one other thing I wanted to highlight on the summary slide. Thank you, Jeff, for that. I didn't include it in the kind of list of takeaways just because I wanted to keep the program pretty tight, but there is some risk in this fourth bullet point in terms of confidential or sensitive information working its way into the public record because of, you know, the nature of the PPP and the fact that, you know, you've got a lot of detail about payroll costs, rent, other related expenses, utilities. The administrative decisions are generally going to be published, and so there may be some information that through the appeals process you want to be more sensitive to and requesting protective orders or redactions for. So again, I think that's a separate point maybe from being prepared for setting yourself up not to have to appeal at all. But if you are in that position of going through the appeal, just something to be mindful of as you're marshaling information and kind of identifying what types of information you might later want to seek a protective order for. Okay, so with that, I think.
And just one point to follow up on that, Eric, because the SBA is subject to FOIA, I believe any of that information would be exempt from a FOIA request. And, you know, so if the SBA received a FOIA request regarding, you know, a borrower's appeal, I think the SBA would be required to redact that sensitive information before producing it.
Mm-hmm. Okay. Well, why don't we just summarize or finalize the program here this morning. For those who are interested, there's some more information here on the next slides about our compliance and audit preparedness program. We've gotten a lot of good feedback from those we've worked with already about this, and have, I don't know, Jeff, you can speak to this a little bit more, but really a good organized process for doing intake of information, organizing that, creating really like an electronic binder or a real binder if a client prefers the physical binder, along with kind of a letter that outlines all the key issues, so that if and when you ever did get to that point of an audit or having to appeal, that you wouldn't be going back to employees who may no longer be there to get information, or trying to dust off memories that are stale at that point. So I don't know if there's anything you want to highlight in kind of the program overview materials here, but I just know anecdotally from the people that we've worked with, clients, that it's been a good process for them. And also, I guess the other thing I'd say, in addition to setting yourself up for a successful appeal, is in many cases we've kind of proactively identified areas where additional forgiveness can be obtained at the outset, that was just kind of missed, just because the regulations are so dense. We were able to kind of pay for the program itself in a few cases very, very easily through a review of the files.
No, I think that's right, Eric. I think, the client feedback we've received has been overwhelmingly positive. I think the program presents a tremendous value proposition, and especially in light of, the recent IFR, and, what we're able to do prospectively is, as Erik pointed out, to not only assist with the record keeping and the justification for the funds and for the forgiveness application, but we're able to do it now through the lens of the SBA's guidance and the regulations in a way that really supports both legally and factually both, the eligibility for the funds, the use of funds, and then the loan forgiveness, in a prospective and not reactionary way. And I think that value proposition based on, the flat fee pricing that we provided is tremendous.
All right. Well, why don't we, unless there are any questions, we can kind of wrap it up there. I think our contact information is up on the, so you can reach out to me or Jeff anytime. Our email and phone numbers are there. I'm sure you can find us. If we haven't connected already, I know many of us have from looking at the attendee report today. So thank you for participating in the webinar, taking the time to do this. It's been very, very gratifying, I guess, to stay in touch with our clients about these important issues throughout the last 5-6 months, and obviously under the worst possible circumstances, but we look forward to being in a position to continue to support you all and the kind of the community when there are issues that come up related to this, and hopefully we keep our small businesses moving forward despite these challenging times. So thank you again.
Thank you.